It's less than 5 minutes?
It will be.
Okay.
Honorable Speaker, sir, honorable members of the Committee on Appointments, my name is Dorcas Oduor. I'm privileged to appear before you today for the purpose of being vetted for the position of Attorney General of this great Republic of Kenya. This is as required under Article 156, Sub-Article 2 of the Constitution of Kenya. Honorable Speaker, sir, and honorable members, I'm deeply, deeply humbled by the confidence and trust which His Excellency the President, Dr. William Samoei Ruto, has shown and placed in me by nominating me to this position. It is also not lost on me that this is a historic moment, in that this will be the first time for a Kenyan woman to be interviewed for this high office in the legal sector. I'm therefore under no illusion that should I be approved by this august House, much would be expected of me, both as a jurist and more significantly as a woman. Mr. Speaker, and honorable members, it would be remiss of me not to acknowledge the fact that, in essence, I do not stand here alone. I stand on the shoulders of many people of goodwill, and I'm a beneficiary of their generous support and mentorship. Their knowledge and wisdom over the years has shaped me into the person I am today. Honorable Speaker and members, for my secondary school education, I attended Luak Girls High School, after which I read law at the University of Nairobi. Thereafter, I gained a postgraduate diploma from the Kenya School of Law. I subsequently attained a Master's of Arts degree at my alma mater, the University of Nairobi. I have also other certificates and commendations from other relevant professional, leadership, management, and other training institutions over the years. Mr. Speaker, sir, and honorable members of this committee, all this I have set in the CV that I have submitted to you. Honorable Speaker, sir, and members, my legal career started in 1992 when I was admitted to the role of Advocate of the High Court of Kenya. I was then employed and served in the State Law Office, rising from the position of State Counsel to the position of Secretary Public Prosecutions, and that was in 2017. This was as a result of the delinking of the Office of the Director of Public Prosecutions from the Office of the Attorney General by the Constitution of Kenya 2010. I have gained extensive experience and expertise throughout that period. Not only have I been involved in many complex courtroom and high-profile cases, I've also made significant contributions in the formulation of policy and other protocols relevant to the rule of law, human rights, crime prevention, locally, regionally, and internationally. This included service in various task forces, commissions of inquiry, and similar bodies and committees. I've outlined this in the dossier I have provided to this honorable committee. Mr. Speaker, and honorable members, I'm alive to the enormity of the responsibility reposed in the office of the Attorney General of the Republic by the Constitution of Kenya. It is no mean task that the Attorney General is the principal legal advisor to the government. The Constitution also mandates the office to promote, protect, and uphold the rule of law, and to defend the public interest. While these high legal concepts are still evolving through the growing jurisprudence in our courts and elsewhere, they nonetheless require of this office a vibrant awareness of the human rights ecosystem within the legal framework. It is therefore my respectful opinion, Honorable Speaker and members, that the position of the Attorney General calls for far much more than just that of an advocate for one client. The public interest demands of the office the duty to respect, advocate, and operationalize at all cadres of the administration this cardinal value of justice. In the circumstances, Mr. Speaker, sir, and honorable members, I would submit that we stand at a unique moment in our constitutional dispensation. It calls for the qualities of listening and learning. Should this House confirm me, I would be determined, as a matter of priority, to pay attention to those two qualities. Not having occupied the position of the Attorney General before, I would obviously benefit from the strengths and victories of my predecessors. I would also seek to collaborate with other persons and agencies to enhance any aspect of the vision and mission of this office, which may still require revitalization. My bounden duty would have to be the delivery of sound, honest, and objective legal advice to the government in accordance with the Constitution of Kenya and my oath of office. Additionally, it would demand proactiveness in the attainment of other core responsibilities in the public interest. All stakeholders in the justice sector have no less duty than that. Accordingly, Mr. Speaker and members, for me, working together will not be an option, but an imperative. Mr. Speaker and honorable members of this committee, in my years of schooling and work, one signal lesson has been imprinted into my intellect and conscience. It is simply this: to act justly, to love mercy, and to walk humbly with my God. That is recorded in the book of Micah 6:8 by Prophet Micah. That is a statement to the fact that I should never take my abilities or capacity for granted, nor should I think low of others. Ultimately, my strength and eventual success may well depend on the counsel and industry of those around me. Honorable Speaker, sir, and members, for that reason, in my respectful view, teamwork will always be key, and I would propose to enhance the same. To that end, Mr. Speaker, sir, and honorable members, I dutifully submit myself to you to this interview. Thank you.
Thank you, nominee. I'll now invite the Deputy Speaker to be the first to ask you a question or comment. And when questions are asked, be concise and precise in your answers.
Thank you, Honorable Speaker. The nominee, Dorcas Oduor, all of us in the legal fraternity know that you have previously worked at the State Law Office and the Prosecution Department. I think mostly people know you as that, as per your CV also. And when the Office of the Director of Public Prosecution was delinked from the Office of the Attorney General in 2010, you transitioned to the Office of the DPP, where you were serving as the second most senior person as Secretary Public Prosecution. Could you share with this committee what you consider was your greatest achievements in the 30 years in your public service? And secondly, if approved as Attorney General, like you rightfully said, you will make history as the first woman Attorney General. Like myself, all the women in the legal fraternity have high expectations of you as one of the most senior women in the legal fraternity. In this regard, tell us what you'd consider to be your vision of the office of the Attorney General should you be approved. Thank you.
Go ahead.
Thank you. I joined the office of the Attorney General in 1992, and I would divide my achievements from the Office of the Attorney General and the Office of the DPP into 4 sectors. When I joined in 1992, for the first 8 years, I was a courtroom lawyer. I prosecuted all manner of cases in all courts to the highest court. The epitome of that was in 2000, when I was nominated to go and assist Kenya in prosecuting the 1998 bomb blast victims, a case in New York. And we successfully did that. Another epitome of my court work was the case that I prosecuted against. It is known as the Gachanja case. The reason why it is my achievement, it is the first time that a prosecutor was able to forfeit instruments of crime and proceeds of crime. In that matter, one of the accused persons had been paid by a piece of land in order to commit murder, and I successfully forfeited what he was paid. That matter went up to the Supreme Court, and it was upheld. My third success in court would be the case of Chris Okemo on extradition. There was a conflict between the Office of the Attorney General and the Office of the DPP as to whose responsibility it is to sign authority to proceed. I did prosecute that case, litigated it, because it was a civil case now. It was a constitutional petition. I did litigate it in the High Court and the Court of Appeal. I filed responses in the Supreme Court. My colleague prosecuted it at the Supreme Court, and we were successful. That matter is now settled, that it is the responsibility of the Director of Public Prosecutions to sign the authority to proceed. That is in the courtroom, among others. While serving in the office of the AG and the DPP, I was able to participate, humbly so. I was appointed by different heads of state in this country to serve in commissions and task forces. I served in the Akiwimi Commission on land clashes, and it is after we had submitted our report that we started land reforms in this country. I served in the Goldenberg Commission, and it is after we submitted our report that we relooked at our PFM Act. I served in the Police Task Force on police reforms, and it is the result of that task force that we now have IPOA, we have the Police Service Commission, we have the IG as a single command of the police and the AP. We also have the merger of the Kenya Police and APs under single command. Other than task forces within the country, I have contributed internationally in different forums. My first contribution was with the Commonwealth Secretariat. I was called in as an expert to review the Harare scheme on mutual legal assistance. It is after my contribution to the ComSec and successful review of that mutual legal assistance scheme that I came back and proposed to Kenya that we needed a Mutual Legal Assistance Act. The Kenya government agreed, and we came up with an act, and that is the act we are dealing with today, the Mutual Legal Assistance Act. Secondly, I have done a lot of work with the FATF. FATF is Financial Action Task Force. It is a group of G7 and other countries. They set standards on issues of money laundering and asset forfeiture. I am a trained evaluator. I've evaluated 2 countries, one in Africa and one in Europe, on compliance with the 40 recommendations. It is after my contribution to that forum that I came back to Kenya together with my colleagues, and we assisted in legislation of POCAMLA, which is Proceeds of Crime and Anti-Money Laundering. It is also after that that we assisted with the legislation of Terrorism Finance Acts. A product of that is the FIU, the Financial Reporting Unit, the Asset Recovery Agency, and the National Task Force. I've also done some work with the UN. And at the UN, I assisted Kenya when we were negotiating the United Nations Convention Against Transnational Organized Crime. I also took part in the evaluation of that convention. I was again called in as an expert to make a digest, which I provided. And in that digest, I am an expert in piracy. After that, the United Nations accredited me as a trainer in that space. I've also done some work with AGA Africa. AGA Africa is a conglomeration of attorney generals. As the Office of the Director of Public Prosecutions, we collaborated with them, and we have all the black attorney generals in the USA in that forum. They have assisted the Office of the Director of Public Prosecutions in many areas, and they have exposed and assisted the DPP to operationalize the PTI. Other than those, I have done work with GIZ with regard to illicit financial flows. Incidentally, when I heard of my nomination, I was representing Kenya at the UN headquarters to take part in the final negotiation of the amendments of the Budapest Convention on Cybercrime to include issues of electronic evidence and data protection. That was the last call for countries to give their views before the amendments are adopted. And I am hoping that after this initiative, Kenya will accede to the Budapest Convention to bridge the gap we have in electronic evidence and data protection. Allow me, Mr. Speaker, sir, to go back to the Office of the Attorney General and the Office of the DPP. I have served in that office in different capacities. I have acted as the DPP in during three transitions, but now I am the Secretary of Public Prosecutions. When we delinked from the Office of the Attorney General, we had only 98 prosecution counsel, and we were in 12 regional offices. It was then my responsibility, together with the DPP, to rationalize staff and to operationalize the Office of the Director of Public Prosecutions. We have managed to increase the staff of the Office of the DPP from 98 to 1,600. We have managed to decentralize the Office of the Director of Public Prosecutions from 12 offices to all the 47 counties, to 131 court stations, and we also serve mobile courts. We have also managed, during that period, to civilize prosecution. What do I mean by this? Initially, police prosecutors were prosecuting in all courts. When we took over, we professionalized prosecution. We no longer have police prosecutors in our courtrooms. This is being done by prosecution counsel. Other than that, when Mr. Haji took over the helm of the Director of Public Prosecutions, he found, when we had an initiative where we were looking at the position or the contribution of the criminal justice sector to the development of this country, and how the Department of Public Prosecutions, or the Office of the Director of Public Prosecution, was assisting or impeding the realization of the objectives of this country. I therefore, together with others, started an initiative called All for Justice. And All for Justice, we wanted to look at the role the prosecution is playing in realizing the objectives of the criminal justice sector. We visited almost all the prisons in Kenya. We interviewed about 20,000 prisoners. And Honorable Speaker and members, to do this because most of the people who were in custody were young. The rights of the detained person, but we have walking outside. And most people who should be outside are in custody. There is a need for us from the criminal justice sector. We also observed that cases were taking very long, and there was a need for us to expedite those cases through the system. We came up with the decision to charge guidelines. The decision to, and that is one of my biggest achievement, our biggest achievement, the decision to charge guidelines is supposed to regulate how we make alternatives to prosecutions. Because we realize that not everybody who is charged with an offense should go through evidence, people should go through court. So we came up with a diversion guideline to assist us to sieve the cases. What is the challenge that the DPP could not deal with that the attorney? but where are the structures to divert to? We found that prosecutors were having difficulty in attending court. We therefore digitized. We have word relief. Order to enhance access to justice. We order to enhance access to justice. We, together with the EU, speakers and members, yes. This experience will help me to oversee and to steer the Office of the Attorney General. Thank you.
Ichungwa, Majority Leader.
Thank you, Honorable Speaker. Honorable Speaker, allow me to also say I know that I arrived here, I think, about 3 or 4 months ago. And we now gave the AG power to recruit you and appoint your own state council. Unlike before, where you had to go through the Public Service Commission. One, I would like to hear your view on whether that was a good thing to do, or if you feel probably those powers should have been left because there was a tussle between the Office of the AG and the Public Service Commission. The Public Service Commission insisting that they should continue appointing, or just want to hear your view on that, whether it's good to have those powers in the AG or whether that should be reviewed to take the powers back for recruitment back to the Public Service Commission. 2, I'd want to hear if, since this is a law now, and government has lost quite a number of cases, large, and some that are very low number of judgments against government in terms of quantum of amount that you intend to do, should you be approved. 1, to make sure that you are able to retain, to recruit entries, and they are poached by Parliament, they are poached by ministries and other organizations.
I am the wrong person to ask, because I fully support this. And this is what has helped the Office of the Director of Public Prosecutions. When we were delinked from the Office of the Attorney General, the ODPP Act, the Office of the Director of Public Prosecutions Act, which operationalized Article 157 of the Constitution, provided for a board, which is chaired by the DPP, and the mandate of this board is to advise the DPP on recruitment discipline of counsel. Why this is a good idea? It gave us the opportunity of relooking at our establishment so that we could get the necessary skills and the requisite officers to propel the Office of the Director of Public Prosecutions. I am the secretary to that board, and I know what we have achieved. We have increased our establishment. We have been able to rationalize our staff. We have been able to negotiate for our staff. As we speak today, it is the Office of the DPP that negotiated with SRC to allow lawyers in government to earn what we call in the ODPP prosecution allowance, and in the Office of the Attorney General it's called another allowance, which is different from non-practicing allowance, and this is to help retain officers. At the same time, it is within that board, which I serve as a secretary, that we were able to find ways of complying with the Constitution. We therefore rationalize staff. If you go to the Office of the Director of Public Prosecutions today, we have 60% women, 40% men. It is the face of Kenya. We have tried to recruit from every part of this country. Secondly, the board has also helped us with issues of discipline because they go quickly and we are able to conclude them within time. Third, the board has assisted because the DPP is required on any other matter to consult the board. So necessarily when it warrants, we go back to the board to get counsel on issues of human resource. And it is through that we have relooked at our human resource manuals, we have looked at our transfer policy, we have also relooked at our work environment. And the beauty of the board is that the PS Treasury is represented. That is at the ODPP's office. The PS Treasury is represented. The Attorney General is represented. The Judiciary is represented. The Kenya Police is represented. The Law Society is represented. So there is collegiality. And we are able to share our expertise and experience on how we can work together as a chain. The second question was a comment on government losing cases and what I would do. Mr. Speaker, sir, and members, there are reasons why people lose cases, not only the government. All of us lose cases one time or another for maybe these three reasons. One, it could be that you have a bad case. You will lose it. It could be that you have bad representation or inadequate representation. You could do that. You could also lose a case because the court has erred. In which case, if you feel aggrieved, you will go back to court, either for appeal or revision. You could also lose a case for any other reason. Any other reason? None of the above. So what I would do, if I'm losing a case because I have a bad case, it would be my responsibility as the Attorney General to make sure that before we go to court, I relook at the cases that we have. I try to mitigate the risk of going to court. And if possible, if I have a bad case, try to find other mechanisms of resolving the issue without going to court and incurring expenses to the government. And going forward, I would also say that it will be the responsibility of the Attorney General to advise ministries and MDAs on how they should deal with court matters such that the Attorney General is involved from the beginning. That is if I have a bad case. If I have inadequate or insufficient representation, I'll look at my capacity and the expertise that I have within the Office of the Attorney General. And this is exactly what we did in the Office of the DPP, because initially we had private counsel assisting us, but with the time, we relooked at the capacities that we have. We have to enhance the capacity of our state counsel, not only legally, but also their working environment and their terms and conditions of service. And we would also want to make sure that there is continuity and succession within the Office of the Attorney General. If I lose a case because the court has erred, I will go back to court on appeal on those issues. I may also go back to court on revision on issues that I think warrant revision. So going forward, if I am confirmed to this position, I will make sure that if I have a bad case, I look for mitigating factors, I do a risk assessment so that I protect the government. If I have insufficient or inadequate representation, I will make sure that wherever the government is to be defended in court, we have the correct people defending the government, we put our foot forward, and we act in the interest of justice. If I lose a case for any other reason, I have recourse to go to the JSC. Thank you.
Jeanette.
Thank you, Mr. Speaker. Mr. Speaker, Madam Nominee, in this vetting, we are looking at your suitability for the job and your competence for the job. Now, I want to ask you this question. One, you have attempted multiple times to become a judge in the Court of Appeal, or once maybe, and despite your impeccable academic credentials and illustrious legal career, you have been bypassed each time. Did JSC provide you with answers as to why they did that? Or was it your last name? What could be the problem? Can you explain to us as a committee what could be the problem? My second question is, it's on record. This country went through post-election violence in 2007, 2008. And you're on record, you say that much later that there is no evidence to charge certain people who were involved in that post-election violence. What else made you make that decision? Can you explain to the committee why you took that decision as a serious prosecutor, a distinguished prosecutor who is known for prosecuting people? Why did you take that decision? And my last one is, there are bills that have passed through this House that have been declared unconstitutional by the court. And some of these bills emanated from the executive. with the participation of the Office of the Attorney General? What will you do to improve the quality of legislation coming from the executive, now that if you are approved, you will become the Attorney General, so that the issues of courts declaring laws enacted by Parliament as a constitution becomes a thing of the past? I have those 3 questions as of now. Thank you.
Dorcas, answer them quickly.
Thank you, sir. About the JSC, I think the positions were few. I'm not the only one who succeeded, but I believe that it was not my time, and my time was going to.
Do they give reasons when they don't give you the job? They don't?
They don't, sir.
Okay.
They don't. About post-election violence, and me having said that there was no reason to prosecute, I want to say that I chaired a task force 3 years down the line to look at offenses that were committed subsequent to the post-election violence. The task force concluded a report that was presented to His Excellency the President, and after it was presented to the President, it was then presented to different arms of government to deal with the recommendations. But as far as prosecution is concerned, I chaired that task force as a prosecutor also, and I was expected to look at the evidence with the lens of a prosecutor, which requires me to be sure that before I can recommend prosecution, I have sufficient evidence and it is in the public interest, and I have a reasonable prospect of conviction. I used the law as it was, and I applied it to the circumstances, and I did my contribution to the task force, and whatever was presented to His Excellency the President was the result of the conclusion of the task force. That task force included civil society. Thank you. About bills going to Parliament and the government losing or courts declaring bills or legislation unconstitutional. First and foremost, it is the work of the courts to do that. That is one of the duties that they've been given. And if they do it, they are not doing a wrong thing. We should ask ourselves, why then the notoriety? I believe that most legislations that we have come up with of late have been to comply or to operationalize the 2010 constitutions. Most of the contents of those bills contain new jurisprudence, not only to the executive, but even to the judiciary. I take it as a testing time. We are testing the Constitution through bills, through legislation. Honorable Speaker and honorable members, a testament to this is that even in the Court of Appeal, there are issues that they've not agreed on, they have not given direction. It is a good thing for us to test a new legislation. It will be volatile for some time, but after some times when we have matured with the 2010 Constitution, then the law will be settled. But that having been said, it is a concern if bills are declared unconstitutional when the Honorable Attorney General has contributed to them. What I would do is to find out why they have been declared unconstitutional. Number 2, I would make sure that as the Attorney General, I advise that wherever we come up with a bill, it meets the constitutional requirements as provided. Thank you.
Now, Dorcas nominee will take a batch of 333, starting with Isola, Posing, then on Gikaria, in that order.
All right, thank you.
One question each, no preambles.
Okay, please allow me to ask two. Chairman, no preamble. You have served in the AG's office before. Are there instances where the AG then advised the executive and the advice was not taken? What will you do if this committee finds you suitable in the National Assembly and you advise the executive on different matters and your advice is not taken. The second question is that there are areas or there are circumstances where cases have been lost in court, as you have said, but then the judiciary then orders compensation to the litigants. My question is, why should taxpayers carry the burden of the compensation while there is an officer in the executive whose decisions have occasioned the judiciary asking that that money should be compensated? And we have many litigants who've never been compensated that the judiciary asked that they get compensated. And lastly, the 2/3 gender rule. How will you make sure it is realized? We cannot selectively follow the Constitution on the matters that suit us, but on matters 2/3 we don't. I will not speak again later, so there's someone who has asked a question from the public, that in Kenya today, the holder of a law degree is not eligible for admission to the role of advocates unless they attend the advocates training program and pass their bar exams. Currently, ATP is only offered at the Kenya School of Law. And so there have been attempts to review the law that mandates this. And so there's and the attempts have been received with different divergent legal view. What is your position on this?
Thank you, Chairman. Mine to the nominee, the Office of Attorney General, is practical one, which is, nominee, I want to know, or the people of Kenya, in assessing your suitability, we want to know, what is your opinion or vision on these contracts or clauses in contracts that a government entity enters with international companies. And in those clauses, the clauses inside those contracts, and I've seen it from being chairman PIC, where Kenya lose money, they put a clause to say that if there's a conflict in that contract, that the arbitration or the legal resolution will be done, for example, in London. And yet, Madam Nominee, through the chairman, the money is paid is 100% exchequer, which means it's our money. And our case in point is GDC, where Kenya lost hundreds of millions of money in London through something I call kangaroo court called arbitration, where people can agree to fleece people's money and agree. Arbitrations
are legitimate courts within both our system and the international systems. They cannot be called kangaroo courts. That's not a fair comment.
I thank you, Honorable Speaker, but that's my opinion. Maybe it's different from the legal practice, but I found it a kangaroo court, Honorable Speaker, that just people sit down and agree. And Kenyans, Madam Nominee, through my speaker, has lost a lot of money through that process. So what's your opinion? Can we change the law and have a contract, particularly where Kenyan money, which is exchequer, maybe if it's a loan, that's a different way. What is your opinion on that, Madam Nominee, so that Kenyans don't lose money as we lost through GDC? I thank you, Speaker, in that kangaroo court.
Not being a lawyer yourself, we forgive you. Go on, Gikaria.
Thank you, Chairman. Chairman, I have this question.
Yes, Junet.
Speaker, I thought Honorable Koseng is a lawyer. I saw him that time when we had the cases in Hague. I saw him carrying a lot of documents and saying that he's filing cases in Hague. And
that is exactly what he was doing, carrying documents. That doesn't make you a lawyer. Go on, Dorcas.
Point of order, Speaker. But
go on, sorry, Gikaria.
Chair, there is this review of the Constitution. There is a call for us to review the Constitution, either be it through the parliamentary initiative or the popular initiative, on some quarters, like not having even the opposition leader in parliament and things like that. And also the very thin line between, like what happened just there recently, on a constitutional issue under Article 37, and the Public Order Act. Maybe in your view, Madam Nominee, what, in your view, are the sections that we need to look for in terms of the constitutional amendment, particularly to be able to align some of those very thin lines between Article 37 and the Public Order Act, where you have to balance the two for us to realize. So maybe in your view, which areas do we need to look for the amendment in the Constitution? Thank you.
Yes, Nominee, can you deal?
Chairman, and my colleagues, my apologies. It has something to do with what I had asked. I just want to know the past costly AG advices to government, mainly driven by vested in-house manipulative cartels, especially in Treasury, and official systems operatives in huge government development projects. I'd like to know your view on that.
You can respond to those three honorable members.
Thank you, Honorable Speaker,
Singh,
sir.
but also don't call arbitrations kangaroo, because they are not.
Thank you, Honorable Speaker, sir, and members of this committee. I am not privy to any advice of an Attorney General under whom I served that was not taken by the executive. As to what I would do if my advice is not taken, I take it that the Constitution provides that the Attorney General is the principal legal advisor to government in legal matters. I look at the President as a vision bearer of the whole country. As he receives advice from the Office of the Attorney General, he has to take into account other sectors, because the law does not exist in a vacuum. He has to take into account socio-economic matters, security matters, and I believe he not only gets advice from the Attorney General, but also from those other sectors. It is the culmination of all these advices from different sectors in which I have no expertise to give that the President of the Republic of Kenya would make a decision. If the President of the Republic of Kenya is the vision bearer and everybody under him is working towards achieving the vision of the government of the day, I do not see where there can be a conflict. Otherwise, for me, I would give efficient, professional advice, which is just, which is fair, which is objective, which is truthful, and which is in accordance with the Constitution. The lost cases in the judiciary, I think it is important for me to say that I am not able to comment on why specific cases are lost unless I am seized with the information. But I also think that it is the responsibility of the Attorney General to put in place mechanisms to mitigate loss. And where loss is occasioned deliberately by an officer, to take action or to recommend action. The 2/3 gender rule. The Constitution provides that in all appointive and elective posts, one gender should not be more than 1/3, 2/3. I think this is an issue that has been litigated. This is an issue that is before this House. And I would be cautious in commenting on it unless I see what is before Parliament and what is in the Office of the Attorney General and the initiative. But I know that in the Office of the in the Office of the Director of Public Prosecutions, we have reached the threshold. Legal education and CLE. This is a rowdy place. Very, very rowdy. Very rowdy. And I say that because I live with some of those people. I have seen them. I empathize and sympathize with them. I understand that there are two task forces that are given reports to the Attorney General. Those reports are in the Office of the Attorney General. And pursuant to those reports, there are two bills pending before Parliament to harmonize legal education, to set standards, accreditation. Because, Mr. Speaker, sir, I am told that in some instances, you go to an accredited university, but when you go to the School of Law, you are not allowed or you are not admitted. I know these people are frustrated, and that is my priority, to go and look at these two reports, to look at what is pending in Parliament, and to make sure that we recall it back, because this was 3-4 years ago. There could be some intervening factors to make sure that we are responsive, because these people need a closure and they need to know. They legitimately expected that after learning law, they would be admitted. So I do agree, this is a very rowdy area, it is frustrating, and it calls for priority, and it will be one of my priorities if I'm accorded an opportunity to serve. At the Office of the Director of Public Prosecutions, having found that this was a problem, we created a cadre called legal interns. We tried to bring in people who had gone through the School of Law, but for one reason or another could not be admitted because they were frustrated. In fact, we started by getting in 100 and we distributed them. But apparently that was not in accordance with what Treasury expected, so we had no money, so we stopped it. I also think that it is the responsibility of the Attorney General to relook at pupillage, so that we can structure some pupillage mechanism within the executive, so that we can absorb some of these children. It is an area that, as an Attorney General, as an advocate, and having been the Secretary of Public Prosecutions, I admit it is an area that needs urgent call. Thank you. I was asked about the vision. The vision of the office. Mr. Speaker, sir, and honorable members, under the Constitution of Kenya, the Attorney General is the principal advisor to the government, also represents the government in courts. At the same time, the Attorney General is supposed to act in public interest. It occurs to me that the Attorney General is wearing two hats. He is a lawyer, he is also a minister. But this public-facing, public interest part has not been very clear. Therefore, I vision to be an Attorney General who will actualize the vision of an Attorney General under the Constitution. Be a principal legal advisor to the government, represent the government efficiently and adequately, and at the same time, protect public interest, uphold rule of law, protect human rights, good governance and accountability. I will be a responsive Attorney General and a lawyer of the people. And I hope the Office of the Attorney General will work with all the peoples of Kenya in realizing our aspirations under the Constitution. When it comes to contracts which are eschewed, Honorable Speaker, sir, I don't have any information on this, but if confirmed, I would make sure that we come up with some SOPs, standard operating procedures. We set standards, and we make sure that the Attorney General is actually represented and reliably represented in the contracts from the beginning to the end. Because unless you look at the quality of the contract and you mitigate any loss or any risk, it is very difficult to succeed in the end. So there is a need for an Attorney General to be represented from the beginning, to look at the clauses to make sure that they're responsive to what we need and that they protect us. At the same time, should we feel that some of the clauses will be injurious to us, we could review. That calls for expertise and very professional state counsel. The third question was on constitutional review. Mr. Speaker, sir, and members, the Constitution is a live document. And within the Constitution itself, there are provisions for review, which means that there is room to review and amend the Constitution. However, the rule of law requires that all laws of Kenya are made by the participation or with the participation of the people. They must be clear, they must be available, and they must be able to be legislated. For that reason, it is only the people of Kenya who can say what they want to change in a constitution, because they have to be part and parcel of the law. The office of the Attorney General can just be facilitative. Having had our constitution for the last 15 years, I would agree with those who are saying we are now ripe to relook at the constitution to see what is working or not working. And this was provided for in the constitution and under the rule of law attributes. A law that is not working should be reviewed, should be amended so that it is responsive, so that it can speak to the times that we live in. So I will facilitate such. Yes. Thank you.
Now we'll take another batch of 3. Let's start with Robert Mbui, Owen Baya, Murugara. Daud, hold your horses.
Thank you, Mr. Speaker, sir. To the nominee, having worked in the office of the DPP, and noting that after we did our vetting in 2022, some of the nominees who had criminal cases against them, immediately after they were appointed, those cases were dropped. Now, as a legal advisor to the executive, if approved, one of the newly appointed CSs, the one for cooperative, the Honorable Wycliffe Mbetsa Oparanya, he confirmed on oath while he was here that the EACC has been used as a political tool to frustrate him when he was not in government. Now, I have 2 issues that I want you to maybe make a comment on. First and foremost, why should EACC be asked to give an opinion when it doesn't matter? Because the opinion given by EACC did not matter in the vetting process, yet we have to fill those documents even when you apply for public office like a member of parliament. 2, what will you do about the government's, what advice will you give, legal advice will you give to the government security organs and legal entities or legal teams, EACC, DCI, DPP, on politicizing and weaponizing their offices? And finally, how will you ensure that justice is served to all those parents and people who lost their lives, who are injured and who lost valuable assets during the recent demonstrations? Thank you, Mr. Speaker.
Thank you very much, Honorable Speaker. This nominee, I've only seen her on TV and newspapers. Now I have opportunity to interact with her. Yeah. But I just want to ask this question, Honorable Speaker. Drafting is very key, especially on laws. And that's probably the link between executive and parliament, is how those laws come in, having passed through the AG's office. I have looked at your CV and I've listened to you. You're a very good litigant or prosecuting lawyer. But I haven't seen your strength in drafting of laws, which is probably one of the key areas that we will need to have in that office to avoid this idea of losing cases as government and passing bad laws. I haven't seen that as strength on your CV. So how will you really help this country moving forward in terms of good laws and good legislation? Secondly, a lot of these laws that have gone to court have fallen on the sword of public participation, which is a key tenet in the Constitution. And everything that we do right now, and every person who goes to court and says there was no public participation, even when public participation has been seen to be done, judges rule in favor of those litigants. What is public participation? What is the correct public participation to you? Or what are you going to do to protect Parliament and this government from that? And lastly, if you allow me, Honorable Speaker, if you look at Section 43 of the County Government Act, it is very clear that the Attorney General may assist counties in matters apart from criminal cases. That is what Section 43 of the County Government Act says. And actually it goes back to Article 156(4) of the Constitution,
But county governments have been using colossal sums of money to hire lawyers without regard to the fact that the Attorney General's job to actually defend county governments. How are we going to stop this hemorrhage of money from county governments through payment to lawyers? I know the lawyers are listening to me and may not be very happy about this, but it is a tenant in the... in the
room.
it is,
There's one next to you.
It is that. Monumental amounts. You look at Nairobi County government, they are running billions in terms of legal fees. And yet, it is the duty of the Office of the Attorney General to assist counties in legal matters. How are you going to do